Hello, thank you for joining today's training. I'm Christina Shaynak-Diaz. I'm a private attorney specializing in behavioral health law, and today's topic is the federal confidentiality laws, including HIPAA, 42 CFR Part 2, and FERPA, and their application to student behavioral health records. Today's presentation is going to provide an overview of each of those laws, their applicability to student behavioral health records. We'll talk about some of the common disclosures that can be made in regard to student behavioral health records, depending on which law applies. And at the end, I'll provide you with some helpful resources in regard to each of these laws as well. So the federal and state confidentiality laws that may apply to students receiving behavioral health services are HIPAA, which protects healthcare information, the confidentiality of substance use disorder patient records, or 42 CFR Part 2 as it's more commonly known. I typically just refer to it as Part 2 throughout the presentation, and it protects substance use disorder treatment records. And then lastly, the Family Educational Rights and Privacy Act, or FERPA, which protects student education records. We're going to talk about the basics of each of these laws, who they apply to, what information they protect, what information can be disclosed without written authorization under each of them, and the role of parents under each of these laws in regards to their students' healthcare records. So starting with HIPAA. HIPAA covered entities, those that must comply with HIPAA's privacy rule, include healthcare providers, regardless of whether they're physical, mental health, addiction services providers that conduct certain transactions in electronic format. All healthcare providers are not covered by HIPAA. HIPAA states that in order to be covered, they have to provide a healthcare service, but they also have to engage in electronic transactions, such as for their billing and enrollment, eligibility, payment, things of that nature. If they engage in those electronic transactions, they would be a HIPAA covered entity. If they're a purely paper-based provider, do all of their billing and other transactions on paper alone, they would not be a HIPAA covered entity. They may choose to comply with HIPAA, but they would not be required to do so. And then the other type of HIPAA covered entity is a health plan, and that can be a private insurance company such as Anthem or United Healthcare. And it could also be a public benefit payer if that public benefit payer's principal purpose is payment for the health care of uninsured persons. So an example of that in Ohio would be Ohio's ADAM boards as payer of behavioral health services. The information that is protected under HIPAA is referred to protected health information, or PHI, and it's information that relates to the person's physical or mental health or condition that is created, received, or transmitted by one of those HIPAA-covered entities in the provision of healthcare or payment for healthcare services, and that identifies the person or can be used to identify the person. So it's pretty much any person-specific information obtained about the person in the course of providing those covered entity services, the provision of care, payment for care. And it goes beyond name and address. It includes about 18 specific identifiers related to that person that may be included in their healthcare record. We're going to talk next about the disclosures that are permitted to be made under HIPAA that might be applicable to the disclosure of student behavioral health records. So the general rule for all three of these federal confidentiality laws is that those that the laws cover that must comply with it are required to obtain the person's written authorization to disclose their protected information unless the applicable laws contain an exception that applies to the disclosure. So HIPAA actually has quite a list of disclosures that can be made without the written authorization of the person, but today we'll only address those that might apply to disclosures of student behavioral health records. So the first one is disclosures for treatment purposes. HIPAA permits a covered healthcare provider to disclose protected health information for its own treatment activities and also for the treatment activities of another healthcare provider, whether or not that healthcare provider is HIPAA covered or not. As I mentioned earlier, some purely paper-based providers are not covered by HIPAA, but HIPAA permits a covered provider to make disclosures of PHI to those non-covered providers if it's for the treatment activities of that healthcare provider. And treatment has a pretty broad definition under HIPAA. It includes the coordination or management of healthcare and related services among healthcare providers, consultation between healthcare providers regarding a patient, or the referral of a patient from one healthcare provider to another. Another disclosure that HIPAA permits to be made without the authorization of the person are disclosures that are necessary to prevent or lessen a serious and imminent threat to the health or safety of the person, to other persons, or the public, and the disclosure is made to persons or entities that are reasonably able to prevent or lessen the threat. So one example would be law enforcement, but it could be any person that's able to prevent or lessen the threat. So it could be a disclosure to a school if threats were made against a school or a student at the school. It could be a disclosure to a parent if a parent is reasonably able to prevent or lessen the threat. And HHS has said that the provider will be presumed to have acted on a good faith belief when making a disclosure for this purpose. HHS said they would not substitute their judgment for the judgment of the provider if the provider believes that this standard is met and makes a disclosure of PHI accordingly. Another disclosure that can be made under HIPAA without written authorization are disclosures to family and caregivers of a person. So parents, as the personal representative of a minor, can receive that minor's protected health information, and we're going to talk more about that in general, but that is the general rule under HIPAA. And then HIPAA also permits disclosures of protected health information to be made to family members or other persons involved in a person's health care to the extent that the disclosure is directly relevant to their involvement in the health care. When the person is present and has the capacity to do so, they must be given the opportunity to agree or object to the disclosure, and if they are not present or they're incapacitated or it's an emergency situation, the provider can use their professional judgment to determine whether that disclosure is in the best interests of the person, and they can go ahead and make the disclosure accordingly if they make that determination. So the next area I want to talk about, and I'm going to do this under all three of the laws so we get a good understanding of what's covered and then how the records of minors are addressed under each of them. We're going to start off with minors and HIPAA and how are minors' records treated under HIPAA and the authority of minors and their parents under HIPAA. So in regard to the general status of parents, HIPAA treats a parent or legal guardian or other person acting in place of a parent that has legal authority to make healthcare decisions about the child as the child's personal representative. And what that essentially means is that the parent stands in the place of the minor, and disclosures can be made to the parent as if they were the child. An exception to that personal representative designation is if the minor is receiving confidential mental health services. If they are receiving confidential services, they are their own, they make their own decisions about their healthcare records, and the parent does not have that personal representative designation. And we'll talk about that a bit more here in a bit. A covered entity may also choose not to treat a parent or guardian as a personal representative of a minor if the provider has a reasonable belief that that minor has been or may be subjected to abuse, violence, or neglect by the parent, or the parent believes that treating the parent as the minor's personal representative could endanger the person, and in exercising their professional judgment, the provider decides it's not in the best interests of the minor to treat the parent as the personal representative. So those are the only two exceptions: minor receiving confidential services, or if the provider makes the selection. Otherwise, the parent is the personal representative of the child and essentially treated as if they are the child in terms of access to their records. What HIPAA says about consent for treatment for the receipt of services. This is something that HIPAA essentially defers to state law on, and says that if state law permits a child to receive confidential mental health services, they can consent for the receipt of their own treatment. So in general, a parent or legal guardian must consent to the provision of healthcare services. But if, under state law, such as in Ohio, a minor is receiving confidential mental health services, then they can consent to receive their own treatment. And what Ohio law says is, in a nutshell, that a minor 14 years or older can receive those confidential mental health services for 6 sessions or 30 days, whichever of those comes first. Those are the maximum services they can receive by providing their own consent. And there's additional parameters around those confidential services. But what is important to note here is that in terms of the parent's access to the records of a minor child, is that the disclosure can be made to parents or guardians as the personal representative of the child, and state law requires disclosure to the parent unless the child is receiving services confidentially, as I just discussed. Another exception to that parent access would be potential abuse, neglect, or endangerment situations. But in general, say for example, there's a troubled teen, a healthcare provider can disclose their concerns about that teen to the parent if the parent consented for treatment and is therefore the personal representative of the child. If the child is receiving those services confidentially, the healthcare provider could only disclose concerns about the child to that parent if there is a potential abuse, neglect, endangerment situation involved, or there's a compelling need for disclosure based on a substantial probability of harm to the minor or other persons if the disclosure is not made. In terms of authorizing disclosure of the minor's records, the parent or legal guardian must generally provide that authorization as the personal representative. Remember, they're standing in the shoes of the child. So if a third party, such as a payer, needs to receive information and the provider needs authorization to make that disclosure, the parent or legal guardian can typically authorize that disclosure. The exception, again, is if the child is receiving confidential services without the knowledge of their parents, the minor must provide authorization to make disclosures to third parties. So as we've talked about, HIPAA protects records of most healthcare providers, but not school-based providers. So HIPAA specifically exempts FERPA-covered education records from coverage under the HIPAA privacy rule. So even if a school-based healthcare provider otherwise meets the definition of a HIPAA-covered entity, and they have to comply with HIPAA's standards for electronic transaction requirements for the purposes of billing, if the treatment records are covered by FERPA, they are exempt from HIPAA. We'll talk about what a school-based provider is a bit later on, but keep in mind at this point that HIPAA exempts from its coverage FERPA-covered education records. All right, so we're going to do the same overview that I just did with HIPAA with respect to the confidentiality of substance use disorder patient records, 42 CFR Part 2. So most substance use disorder treatment programs are considered to be Part 2 programs under the federal law. That's regardless of whether they are school or community-based. SUD treatment program is any program providing treatment services, referral for treatment, or diagnosis for treatment that either receives federal funding, is granted 501c3 status, is registered to dispense controlled substance, authorized by the federal government to conduct maintenance treatment or withdrawal management, if they're a Medicare participating provider, essentially any type of federal connection or authorization that they may have, including just 501c3 status, brings them under the coverage of 42 CFR Part 2 if they're otherwise providing substance use disorder treatment or related services. Those Part 2 programs are required to comply with the disclosure requirements. There's also a new category of entities that are not technically covered programs under Part 2, but that are still subject to the disclosure requirements under Part 2. And those entities or persons are referred to as lawful holders of Part 2 information. People or organizations that receive Part 2 protected information from a Part 2 program are required to only disclose that information to a third party in accordance with Part 2's disclosure requirements. And that goes on down the line. So persons or entities that receive Part 2 protected information from a lawful holder must also comply with Part 2's disclosure requirements. Essentially, it's clear that Part 2 protected information that originates with an SUD treatment program is intended to be protected on down the line wherever it goes to, either pursuant to the person's authorization or under one of the exceptions to the written authorization requirement. Information that is protected under Part 2 is information that is created or obtained by a Part 2 program for the purpose of substance use disorder treatment, making a diagnosis for treatment or referral for treatment, and that also identifies a person as a recipient of substance use disorder services or as having a substance use disorder. So whereas HIPAA protects pretty much any information obtained by a covered program that identifies a person, Part 2 only protects the information that would specifically identify the person as receiving substance use disorder services or as having a substance use disorder issue. It does not protect other personal information about the person, although of course HIPAA would most likely continue protecting that additional information about the person. And the information becomes protected under Part 2 at the point the person seeks, applies for, inquires directly about services. So even if they never show up for treatment, it is still protected that they sought treatment. Applicable disclosures that can be made under 42 CFR Part 2 without the written authorization of the person are rather limited to begin with, and there's really only one that could apply to our focus on students receiving behavioral health services, and it states that in medical emergencies, Part 2 protected information can be disclosed without the person's authorization to medical personnel who have a need for the information for the purpose of treating a condition which poses an immediate threat to the health of the person and that requires immediate medical intervention. So it is very specific in terms of it has to be for an emergency medical need, and it has to be a disclosure to medical personnel who are treating that emergency medical need. Redisclosures of Part 2 information, unlike the other two laws, redisclosure by the recipient is generally not permitted, and we saw that with the concept of a lawful holder, and on down the line, those that receive protected information from a lawful holder, that information continues to be protected. So under the other two laws, if the recipient is not also a covered entity or a covered FERPA entity, they're not bound by the requirements, and redisclosure can generally be made of that information, but that's not the case under Part 2 since the information continues to be protected wherever it is passed to. Okay, just like we looked at HIPAA and minors, we're going to look at 42 CFR Part 2 and what it has to say about minors. In regard to the status of parents, minors have rights greater than or equal to that of their parents with respect to their Part 2 protected treatment information. And we'll look at what that means a bit more. But whereas with HIPAA, we saw that the parent stands in place of the child, Part 2 gives much greater rights in terms of that Part 2 protected information. So when it comes to providing consent for substance use disorder treatment, in general, the parent or the legal guardian must consent to the provision of substance use disorder treatment services. The exception would be under state law, under Ohio law, if the minor is receiving confidential substance use disorder services. So just as Ohio law provides for minors to receive confidential mental health services under certain conditions, Ohio law also does the same in terms of substance use disorder services. Unlike HIPAA, there is no age or session limit for confidential substance use disorder services. A child of any age can request confidential substance use disorder services, and they can receive them for an unlimited period of time, unlimited number of sessions. An additional condition of the receipt of those services is that they have to be provided by a licensed physician or a person acting at a licensed physician's direction. Another additional requirement related to consent for substance use disorder treatment under Part 2 is that if parental consent is needed for treatment. For example, there's no licensed physician to provide or oversee the treatment, then the minor's request for treatment can only be communicated to the parent if the minor consents, or if there is a determination by the Part 2 program director that the minor lacks the capacity to make a rational choice as to whether to give consent to disclose to the parent. And in addition to lacking capacity, the minor's situation poses a substantial threat to the life or physical well-being of the minor or another person. So essentially, if a substance use disorder treatment service request is made by a minor, and the minor isn't eligible for confidential services, again, because there's no licensed treatment or no licensed physician available to oversee the services, the Part 2 program would then have to get the authorization of the child to communicate to the parent that that request was made, or they have to make that determination about lacking in capacity, and there's a substantial threat to the child if they don't communicate the request for services and what they know about that request for services to the parent. In regard to parent access to minors' record under 42 CFR Part 2, it is again very different than HIPAA. Part 2 states that the minor must provide authorization to disclose information to their parents or legal guardian unless the minor has been adjudicated as lacking capacity. So even if the parent has consented to the treatment of the minor still must provide authorization to disclose any additional information to their parents unless they have actually been adjudicated as lacking capacity. Disclosures to third parties under 42 CFR Part 2 requires both the minor and the parent's authorization, again, unless the child has been adjudicated as lacking capacity. So not only does the parent have to sign off on the disclosure of information to a third party, but the minor has to do so as well. Unless the minor is receiving those confidential services, then only the minor provides the authorization. And not only is this a requirement under 42 CFR Part 2, but the Ohio Department of Mental Health and Addiction Services has this same requirement in its confidentiality rules that both must sign off on such disclosures. And then unlike HIPAA that exempts FERPA covered records from its privacy rule, Part 2 and FERPA can both apply to a student's health records. And we're going to talk a little bit more in detail about that as we move on with the presentation. But just keep in mind for now that FERPA and Part 2 can apply to the same records at the same time. And we'll have to take into account what that means for student behavioral health records. All right, moving on to FERPA and doing the same overview that we did with the other two laws. FERPA covered agencies include all educational agencies and institutions that receive funds under any Department of Education program. It's pretty much every public school and school district, most private and public post-secondary institutions. It is typically not applicable to private and religious schools because they generally do not receive Department of Education funding. Because FERPA does not apply usually to religious and private schools, HIPAA might apply to those schools still if the school has healthcare providers that bill electronically for services such as to Medicaid. And some private and religious schools that don't provide healthcare services that are billed for electronically would not be covered by HIPAA or FERPA. In terms of FERPA protected information, PII is what it protects. It's personally identifiable information, and it is PII that's contained in education records. And under FERPA, an education record is a record that written information that directly relates to a student and is maintained by an educational agency or institution or a person acting on behalf of an educational agency or institution. Education records do not include verbal communications, personal notes of a school administrator or school official, and personal observations. Something that I want to point out to you that will have some differences when we move forward looking at behavioral health records of students is at the elementary and secondary level, student health records are called education records. Once a child either obtains the age of 18 or begins attending a post-secondary institution, even if they are under the age of 18, the child is referred to as an eligible student under FERPA. And FERPA says that the health records of an eligible student are excluded from the definition of education records that I just gave you, and instead are referred to as treatment records. And these FERPA education records are treated differently than FERPA treatment records, and we will talk about that a bit more as we move forward. So just as I gave you a list of HIPAA and Part 2 permitted disclosures that might apply to student behavioral health records, we're also going to go over some of the applicable FERPA permitted disclosures that might apply to those records. So FERPA permits disclosures of FERPA covered records to be made to the parents of the student. As I mentioned, they essentially have a right to access under FERPA, and to school officials. FERPA disclosures can be made to school officials, including teachers and administrators, with a legitimate educational interest in the information. So what's important to note here is even within a school or educational institution itself, to make disclosures to other school officials, that school official must have a legitimate educational interest. It's not just because they're under the umbrella of the same institution they can freely disclose information. There's still this bar that must be met. And FERPA says that a legitimate educational interest is one that serves the student, protects the health, safety, and learning of the student or others, maintains the operations of the school district, or if it's needed to obtain payment for educational programs and services. Those all fall under the category of legitimate educational interest. And if a school official needs FERPA protected information for one of those purposes, that information can be disclosed to them by another school official or administrator. Other applicable FERPA disclosures are similar to HIPAA, disclosures to appropriate persons in health and safety emergencies. So FERPA says that if there is a specific situation that presents imminent danger or requires an imminent need for information to avert a serious threat to the health or safety of the student or other individuals, disclosure can be made to a person whose knowledge of the information is necessary to protect the health and safety of that person or others. So just like with HIPAA, when there is that imminent health or safety emergency, a disclosure of FERPA covered information can be made to a parent, to police, to others that are in a position to help reduce the likelihood of that health or safety emergency. And just like with HIPAA, in terms of what HHS said, the Ohio Department of Education has said with FERPA and disclosures for these purposes that based on the information available to a school official at the time of the determination, there's a rational basis for them determining that there was a health or safety emergency. The Department of Education will not substitute its judgment for that of the educational agency in determining whether that disclosure was appropriate or not. It will essentially defer to the educational agency and presume that that disclosure met the requirements. Another FERPA permitted disclosure is a disclosure of student directory information, just like hospitals might have facility directories where they can disclose limited information. Schools can have student directory information that a parent can opt out of, but if they have not opted out, then schools and educational institutions can make disclosures of what falls under the heading of student directory information: name, address, phone number, date of birth, and dates of attendance. And please note, as I mentioned at the bottom here, that treatment records of an eligible student, which, as I mentioned earlier on, are those students that have either reached the age of 18 or that at any age are attending a post-secondary institution, may be disclosed pursuant to these exceptions. But if those treatment records are disclosed pursuant to these exceptions, the records then become education records subject to all FERPA requirements, and that can have implications for who the information can be disclosed to. And we're not going to go into a lot of detail about that today, but keep in mind that those treatment records of the older students could lose that additional level of protected status if disclosures are made under this laundry list of disclosures I just provided. And then looking at FERPA and minors, just like we did for HIPAA in Part 2, the status of parents under FERPA, and essentially the main tenet of FERPA is that parents have certain rights with respect to their children's education records. And keep in mind, this is education records, not those treatment records of the eligible student, the older student. They have rights in regard to their own treatment records unless they would lose that protected status, as I just mentioned. So providing consent for a student to receive services under HIPAA, under FERPA, school counseling is considered to be a regular educational service. So a minor can receive school counseling without their parents' consent, since it's an educational service, but a parent can specifically forbid school counselor services unless they have stated that they forbid their child to receive school counselor services. Then it can be provided without obtaining parent consent. Parent consent typically is needed for group sessions because of the more sensitive nature of sharing in a group setting. And a school district is permitted under FERPA to have additional policies regarding services it provides and parent permission. In regard to parent access to a minor's records under FERPA, FERPA provides parents with the right to inspect their child's education records, which includes the records of a FERPA-covered health provider. So it requires disclosures of records to parents when parents request access. And that's unless the student is one of those eligible students. Again, when they turn 18, they enter the post-secondary institution, whichever is first. These rights under FERPA transfer to the student, and the parent would no longer have access. Authorizing disclosures of a minor's record under FERPA, the parent must provide written authorization unless the minor is that eligible student. And there are specific requirements for disclosing information to third parties under FERPA, just like there are specific requirements for the written authorization itself under FERPA and HIPAA. So keep in mind under each of these laws, when I've talked about written authorization being required, it's not just a general statement under any of them that permission is given, just like in for those of you that are HIPAA covered providers, you know, specific statements and specific information need to be included on that written authorization form. Same applies for 42 CFR Part 2, and same applies for FERPA. So if you are attempting to create an authorization form that permits disclosures under all three of these laws, you have to make sure that the specific requirements under each of those laws are included in the written authorization form. All right, now that we have an understanding of each of the federal confidentiality laws that may apply to student behavioral health records, let's look at how they interact with one another and determine when each law applies. So the intersection of each of these laws is what I've attempted to capture here. So we have HIPAA protecting health records, 42 CFR Part 2, protecting substance use disorder treatment records, and FERPA protecting education records. What's important to note about how the three of these work together is FERPA and HIPAA do not overlap. One or the other applies. Again, FERPA education records are exempt from HIPAA, even if HIPAA would otherwise apply to the school or educational institution in regard to the electronic transactions that they may utilize. The records are exempt from HIPAA. Part 2 overlaps with both FERPA and HIPAA. You can have records that are both HIPAA and Part 2 protected, and that are both Part 2 and FERPA protected. And what's important to note there at this point is that when the federal confidentiality laws overlap with one another, the one that is most protective of the person's information applies to the disclosure of information. So say, for example, HIPAA and Part 2 apply to a person's health information. HIPAA has a authorizes disclosures for treatment purposes without written authorization. Part 2 doesn't have a treatment exception to the written authorization requirement because Part 2 is more protective in that regard, and both of them apply to the information. Written authorization would have to be obtained in order to disclose that information for treatment purposes. And same for Part 2 and FERPA. So for example, whereas if the record is covered by both FERPA and Part 2, we know FERPA allows disclosures to avert a serious risk to health or safety. Part 2 does not. There would need to be an authorization for that purpose, or the disclosure would have to be made in a way that does not disclose Part 2 protected information. If you recall early on, I stated that Part 2 is specific to Part 2 identifying information. So it could be that even if information is covered by both of these laws, there's no need to disclose the substance use disorder specific information, and the disclosure can go ahead and be made under FERPA, as FERPA permits, to avert a serious risk to health or safety. And we're going to talk a bit more about how this intersection of these laws and where they overlap and where they do not applies as we move forward. So the big question, assuming that a school is FERPA covered, not a private or religious school, does HIPAA or FERPA apply to the behavioral health records of students? And this is a big question because, as we've seen, it determines what disclosures can be made, the parents' right of access to the information, who else can access minors' information, and who can authorize disclosure of a minor's information. So knowing whether HIPAA or FERPA applies is very important. And also, you know, I had mentioned that HIPAA has quite a laundry list of disclosures that can be made without written authorization, where FERPA is very limited. So knowing which law applies can very much impact disclosures that can be made without authorization. So the answer to this big question can be very clear cut, or it can be a very gray area. So let's first address some of those more clear cut answers to this question. So HIPAA applies to a student's behavioral health records if it is clear that the treatment provider who made the record is not acting for a school or an educational institution. So they're not employed by a third-party contractor of, or otherwise acting on behalf of the school. So if a provider is funded, administered, operated by, or on behalf of a public or private health, social services, or other non-educational agency or individual, then the records are not FERPA covered. Then HIPAA would apply. So if the provider is not acting on behalf of the school, it is typically not going to be an education record. It's going to be a HIPAA covered, protected health information, and has to be handled in accordance with HIPAA and not FERPA. Conversely, FERPA applies if the provider is acting for a school or educational agency. So if they're employed by a third-party contractor of, or otherwise under the direct control of a school or educational agency, or if the provider is funded, administered, and operated by, or on behalf of a school or educational agency, it's going to be a FERPA covered record. So say, for example, the mental health treatment records that are prepared by a counselor employed by the school, by a school counselor, those are going to be FERPA covered records. The counselor is employed by the school. The records created in regard to mental health services provided to a student are going to be FERPA covered records. So acting on behalf of the school equals an education record equals FERPA applies. I'll get to what I said about even funding originating from a HIPAA covered source on a different slide. So when it is not so clear cut as what I just had on those slides, when it's not an employee of the school or a person acting under the direct control of a school, there are some additional considerations to take into account when you're trying to determine if HIPAA or if FERPA apply. And a good general rule of thumb is that HIPAA applies if the provider is billing directly to a health plan. If the services that are being provided are being billed to an external source, to a health plan, it's a good bet that HIPAA is going to apply. But let's look at some of the additional considerations that may fall under that. So if a person is hired or contracted with to fill an institutional, a school position that would otherwise be filled by a school employee, such as a district school psychologist position that's open but is hired out, is outsourced essentially, that most likely would then be their records of students receiving services from them would most likely be FERPA covered because they are under the direct control of the school by filling an institutional position, even though it's via contract. Another consideration is it a school employer agent, like one I just mentioned, or is it a community mental health provider employee or agent? So say, for example, in Ohio's behavioral health system, our community mental health providers have employees go into the school sometimes to provide services, but they are an employee, an agent of the community mental health provider in most instances and not of the school. Therefore, the records they create for the provision of services to students would be HIPAA covered. Another consideration, which entity has operational or administrative control over the services? Again, is it a community mental health provider that has control over the services, operational or administrative control over the service provider, or is it the school? Are the services provided by a separate healthcare agency or a healthcare provider? Kind of the same thing. Is it community-based as opposed to a school-based agency? And, you know, each of these aren't determinative in and of themselves, you know, one way or another with HIPAA or FERPA. They're all to be considered when we don't have that clear-cut answer, when we need to determine whether HIPAA or FERPA applies to the records. And then is the provider, another consideration could be, is the provider placed in the school as part of a community continuum of care? So perhaps they are located within the school, but they were placed there as part of a community continuum of care, making sure services are available everywhere in the community, including the schools. What is not considered to be a factor in making this determination is where services are provided. And I just mentioned that. If we go back to the last slide, that last one was, you know, is the provider being placed in the school, providing services in the school, but it's part of a community-based system, and they're still not under the operational or administrative control of the school. So where services are provided are not determinative in this regard. And same with where records are maintained. They might be kept at the school, but it's a community-based provider employed by a community mental health agency that's providing the services, and they just keep the records on site because that's where they're providing the services to students. And then the source of funds is also not an issue, and I should have been more specific on this slide. The source of funds to hire or contract with the service provider is what I'm referring to here. So say, for example, the Ohio Department of Mental Health and Addiction Services provides a grant that's used to hire a school counselor. That position is still FERPA covered, even though the funding came from an outside entity, a HIPAA covered entity, because that person is still employed by the school. It doesn't matter where the funds came from to pay for that person's employment. What matters is that they are employed by the school. So if a person falls somewhere in between, I shouldn't say a person, if the records of a student receiving behavioral health services falls somewhere in between the more black and white determination of HIPAA or FERPA, and there are, you know, situations that arise where it is a very difficult call to make in terms of which law applies. It's best to contact for that organization or that service provider to contact legal counsel to really have the exact circumstances of those services looked at and who they're being provided on behalf of in order to make that determination. And there could very well be some areas where records, a person with two hats might have to comply with two set of rules. So you might have a community mental health provider that is also a contracted school counselor. They're filling both roles, and they may be dealing with two sets of records that are covered by two different federal confidentiality laws, and they will have to apply those laws accordingly based on which apply to their sets of records. So it can get very convoluted in some regards, but you know what you want to keep in mind, and I'm going to go back a couple slides, are these key things of whether the provider is acting for the school under their control, or are they acting under control of an outside entity, a public or private health, social services, mental health, other non-educational agency or individual. That's going to be your first determiner of whether HIPAA or FERPA applies. And if it is not clear cut or there are additional things involved in a particular situation, you want to look at these additional considerations. I would say that for the purposes of Ohio's community mental health system, based on what that general rule of thumb is that I have at the top of this slide, if an ADAM board, if one of Ohio's alcohol, drug addiction, and mental health services boards is funding the provision of services as part of its county's behavioral health system services, it would be a good bet that those records are covered by HIPAA and not FERPA, even if the provider themselves is providing those services within the school, and regardless of whether they maintain the records at the school, all those other non-factors that I mentioned in making this determination. And then once we know whether records are HIPAA or FERPA covered, keep in mind that Part 2 may also apply if a Part 2 covered program is providing the service. So that could be a community addiction services provider or a school program providing substance use diagnosis, treatment, or referral for treatment services. So you could have HIPAA on the one end and FERPA on the other, and Part 2 could apply to one or both of them, regardless of whether HIPAA or FERPA also apply, and also regardless of the provider's relationship with the school, program administration, funding, any of those other factors don't need to be taken into account. What matters is if it is a Part 2 program under the definition that we talked about early on, providing the service, then the records would also be Part 2 covered in addition to HIPAA or FERPA. So once you know what law applies to the records, you need to determine how disclosures can be made between community and school-based providers and school administrators, and that's what we'll turn to next. So let's start with disclosures a HIPAA-covered provider can make to school officials or school employees. So as we talked about, HIPAA permits providers to make disclosures to another treatment provider. So that could be a school nurse or a guidance counselor. Even though one's a HIPAA-covered provider and one is covered by FERPA, HIPAA permits those disclosures to be made to other treatment providers, HIPAA covered or not, as we talked about. So for example, medication needs can be disclosed to a school nurse that will administer the medication at school that disclosure can be made by a HIPAA covered provider. Another disclosure that we talked about permitted by HIPAA would be to avert a serious threat or a medical emergency. So if there's a threat against the school, that school would be in the best position to lessen or prevent the threat, or one of the persons or organizations in a position to do so. So a HIPAA-covered provider can disclose information about that threat or some type of threat to health or safety to school administrators, whether it's a treatment provider or not. For the purposes of that disclosure, it can be made to any person that is likely able to lessen the threat. So that could be a school principal, school administrator. It doesn't have to be a provider at the school. Keep in mind that PHI that is disclosed by a HIPAA-covered provider, once it's recorded by the school that receives it under one of these exceptions, it becomes part of the education record, and FERPA becomes FERPA covered and can only be disclosed further per FERPA's disclosure requirement. So it started out as protected health information. It was disclosed under a HIPAA permitted disclosure. Once it's recorded by a FERPA covered school official, it is now FERPA covered information and can only be disclosed in accordance with FERPA. So disclosures by a Part 2 provider to a school. So in general, a Part 2 provider can't disclose information to school administrators or to school treatment providers without authorization. But if a Part 2 provider is set up as a student assistance program, or there's a treatment team set up within the school, Part 2 permits internal program communications to be made within a program or within a treatment team. So say, for example, a student assistance program is set up and it includes a Part 2 covered provider, and it includes a school guidance counselor, and it includes a school administrator that's ensuring that the student can get the accommodations they need at school in order to for them to get their healthcare or treatment needs met, medications, things of that nature. If they're all part of the same treatment team or the student assistance program, Part 2 permits communications to be made to those within the same program. So setting things up that way is a good way for Part 2 protected information to be communicated with those in a school. As we saw, Part 2 has very specific or very stringent disclosure requirements. It doesn't allow a lot of disclosures to be made without authorization. So this is one way disclosures that are necessary to be made to those within the school, that it can happen if they're within the same treatment team or student assistance program. And also keep in mind that, as I mentioned earlier on, just as a larger picture consideration, information that doesn't disclose the student has a substance use disorder, is receiving substance use disorder services, aren't protected by Part 2. So a Part 2 program can make a disclosure to a school if there's nothing substance use disorder specific about the disclosure that would otherwise indicate that the person is receiving substance use disorder services. So in regard to the disclosures the school is permitted to make to a HIPAA covered provider. So we're talking about information from FERPA covered education records. FERPA covered education records information would be able to be shared with a HIPAA covered provider with parent consent. In general, there really are no other exceptions to the authorization requirement. So with parent consent, but also keep in mind that verbal communications and personal observations are not records under FERPA. So for example, a teacher or a school guidance counselor could share with a outside HIPAA covered provider what they witnessed with a student involving a bullying incident, for example. Because it was just a personal observation and it's being verbally communicated, it's not a record under FERPA, and that disclosure can be made. Also, I talked about limited student directory information, which could include dates of attendance. So even though dates of attendance would be part of the education record, if an outside HIPAA covered provider is trying to look at absences from school, the FERPA covered provider, school official, could disclose that information to the HIPAA covered provider because school dates of attendance are part of that student directory information that could be disclosed without the parent's authorization. And then there was also the medical and health emergencies exception that we just talked about under FERPA. If the FERPA covered school official believes that a HIPAA covered provider is in a position to lessen a threat to health or safety of the student or others, then a disclosure can be made to that HIPAA covered provider. In regards to disclosures the school is permitted to make to a Part 2 covered provider, it's pretty much the same thing that I just talked about in terms of disclosures to a HIPAA covered provider, except that if the provider is considered to be a school official with a legitimate educational interest because they are part of that internal student assistance program I talked about, then disclosures could be made to them as well. They would be considered in that regard that school official with a legitimate educational interest. And then keep in mind that FERPA is, I skipped ahead a slide. FERPA is different from HIPAA and Part 2 in that it restricts internal disclosures among school officials under the same school umbrella, and only permits disclosures to another school official when there is that legitimate educational interest in the info that I talked about early on. So information from let's say, for example, educational record information such as disciplinary actions and grades can be disclosed to other school officials if they have a legitimate educational interest, even if it's another treatment provider. So say, for example, that the school principal thinks that the school guidance counselor has a legitimate educational interest in knowing what disciplinary action has been taken against a student or the student's grades, either for the school counselor to reach out to the student or for purposes of ongoing services provided to that student, then that disclosure can be made from the principal to the guidance counselor. And this requirement for the legitimate educational interest in the information is even if it is a school psychologist and a school guidance counselor, there is still that bar that must be met that the other one has a legitimate educational interest in the information, and that it's not just being provided as a matter of course. But again, keep in mind that sharing information, just like we talked about with a student assistance program, sharing information with a team that are all trying to keep eyes on or consult with or look out for or provide services to a student would be a legitimate educational interest. But those school-based counselors, those school-based psychologists do have to make sure that, for example, when a principal approaches them wanting information about who they're seeing and for what reasons, they have to make sure that that information is being disclosed because the principal has a legitimate educational interest in the information that is being requested. When it comes to parent access, this is the last thing I wanted to talk about today. We've talked about the disclosures that can be made amongst school officials between HIPAA and FERPA and Part 2 covered entities. I want to wrap up today with talking about a conflict that occurs when parent access is requested. So what we have seen is that FERPA provides a parent right to access. That's essentially the whole intent, other than protecting educational records, is to provide parents the right to access their students' educational records. We have also seen that 42 CFR Part 2 prohibits disclosures to a parent without the child consenting to that disclosure unless they have been adjudicated as lacking capacity. This means that when a parent requests access to a student's education records, and those education records include Part 2 protected information, FERPA and Part 2 are going to be in conflict. So if the child is receiving services from a Part 2 program and they refuse to authorize disclosure of FERPA covered records to the parents, the best thing you can do is seek legal advice, because you are essentially caught between two federal confidentiality laws. And that's the case even if the minor is receiving confidential services. FERPA still applies, so the parent has access, a right of access to the information, and the Part 2 program prohibits disclosure of that information, and you have a conflict. And this has been such an issue over the years that in 1990, the U.S. Department of Education and SAMHSA, the Substance Abuse and Mental Health Services Administration, issued a joint opinion suggesting potential solutions to this conflict between the two laws, the conflict that exists when both FERPA and 42 CFR Part 2 apply to records to be disclosed. And what they recommended is that parents can only access the student records, so limit what becomes a student record. So what they were essentially saying is, don't write everything down. The personal notes of the provider, their personal observations, the oral communications are not records. So if things pertaining to Part 2 services provided to the student don't have to be written down, don't write them down, because then when a parent requests access to the information, there's no disclosure of Part 2 protected information. So whenever possible, keep Part 2 protected information out of education records by either the provider keeping their own notes, sharing their own personal observations, or just keeping it with oral communications. And another recommendation that came from that joint letter was to attempt to obtain the minor's authorization to disclose information to their parents as a condition of them providing services. And the authorization can even be specific to state that they're only authorizing disclosures to parents who make requests under FERPA. So they're not authorizing disclosures as just a matter of course to parents whenever the school wants to make that disclosure, the Part 2 program wants to make that disclosure. There's authorizing disclosures when a parent specifically makes a FERPA covered request. I don't know that either of these recommendations from ODE and SAMHSA are the best to resolve this conflict because sometimes things need to be written down and documented, and other times the minor is not going to authorize treatment, and you really don't want to hold that over their head as a condition of treatment. So really the only other option in that regard is the court order could always be obtained. I'm guessing this doesn't happen frequently, where both Part 2 and FERPA apply and a parent has requested access to the record. But if it does come down to that and a potential violation of one of the federal laws, the FERPA or Part 2 covered entity could seek a court order authorizing disclosure of information to the parents. And if that court order is issued in accordance with the requirements of HIPAA or Part 2 for disclosing protected information, that court order would allow the disclosure to be made and would clear up that conflict. So hopefully what we have went over today will be beneficial to you in terms of determining who is covered by each of the laws, what information is covered by each of these laws, the parent's role and rights under each of these laws, the minor's role and rights under each of these laws, and then ultimately determining what law applies to a student's behavioral health records, whether it be HIPAA or FERPA, and then lastly, trying to work out the Part 2 and FERPA related issues. I do have some additional resources for you listed here. These are just links to the Part 2 regulations, to the HHS website that provides great information about HIPAA, including FERPA and HIPAA and the HIPAA regulations themselves. I have a link there to the FERPA regulations. And then on this last slide, I have a link to the Ohio Revised Code and the Administrative Code. They can both be found at codes.ohio.gov. You can look up Ohio's confidentiality laws there for behavioral health records under Department of Mental Health and Addiction Services, rules and statute. And you can also look up the statutes that provide for minors to receive confidential mental health and addiction services as well. And then lastly, what I have there is a link to that joint guidance on, actually, I'm not sure if I mentioned this earlier on, but FERPA and HIPAA's application to student health records is the subject of joint guidance that was put out by SAMHSA and the Ohio Department of Education, different from that guidance that was put out in terms of the parent access issue. This guidance here addresses, it's probably 35 pages of essentially FAQs on when FERPA applies and when HIPAA applies to student health records, and also just an overview of those laws such as I laid out today. So it's really an excellent resource if you have questions about FERPA in general, HIPAA in general, and when one or the other applies. So that's all I have for today's presentation. I hope you have found it to be helpful and informative. Thank you and have a good day.